A federal judge just stripped 3 of Trump's attorneys of their right to practice in her courtroom. The order came down Thursday afternoon in a Washington, D.C. federal courthouse, and within minutes, U.S. Marshals escorted the legal team from the building. This isn't some minor procedural sanction or routine courtroom dispute. This is a sitting federal judge declaring that attorneys representing a former president engaged in conduct so egregious that they can no longer be trusted to appear before her court. When marshals physically remove a defense team from federal proceedings, you know something unprecedented has just unfolded. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this extraordinary action? Judge Tanya Chutkan, overseeing the January 6th federal case, issued a 38-page order that methodically documented what she called a sustained pattern of misconduct, misrepresentation, and obstruction that strikes at the heart of this court's ability to administer justice. Sources familiar with the proceedings say the order uses language virtually unheard of in federal court filings, including phrases like deliberate deception, coordinated bad faith, and in one particularly devastating passage, conduct that would warrant disbarment in any jurisdiction that takes legal ethics seriously. This isn't just another legal controversy or typical courtroom tension. When a federal judge revokes practice privileges and orders physical removal of counsel, the situation has escalated beyond anything in modern legal memory. And believe me, when U.S. Marshals escort attorneys out of a federal courthouse, something catastrophic has just detonated. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and Judge Chutkan have been building for months, fueled by repeated missed deadlines, filings that contradicted previous sworn statements, and an escalating series of personal attacks on the judge herself. But everything exploded on January 14th when prosecutors from the special counsel's office presented evidence in a sealed emergency hearing that the defense team had been aware of for months. The evidence contained in a 156-page filing dated January 11th reportedly documented what prosecutors called a systematic campaign to deceive this court and obstruct the administration of justice. This wasn't about aggressive advocacy or zealous representation. It was about attorneys allegedly filing motions they knew contained false statements, concealing discoverable evidence, and coordinating with outside parties to intimidate potential witnesses. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkan reviewed the sealed evidence in chambers, she recognized immediately that this crossed every line of professional conduct. And let's be honest for a moment. Federal judges don't strip attorneys of practice privileges lightly. They don't order U.S. Marshals to remove counsel from courtrooms unless something has gone catastrophically wrong. This happens when a judge concludes that the attorneys themselves have become participants in obstruction rather than advocates for their client. Here's what multiple sources say happened during the explosive hearing. On January 15th, the special counsel's team presented their evidence in open court after Judge Chutkan ruled that the public interest in transparency outweighed any claims of attorney-client privilege that might otherwise apply. The lead prosecutor, a senior Justice Department attorney named Thomas Wyndham, who has handled some of the most complex public corruption cases in federal history, stood before the court and presented what he called irrefutable documentation of attorney misconduct. The presentation lasted nearly 4 hours. It included emails between members of Trump's legal team discussing how to slow-walk discovery responses. It included text messages referencing a witness who needed to be reminded of the consequences of disloyalty. It included billing records showing that attorneys had charged for work on motions they later acknowledged were filed solely for delay. Sources told CNN that Judge Chutkan's expression grew increasingly severe as the evidence mounted. Trump's lead attorney, John Lauro, attempted to object multiple times during the presentation. Each time, Judge Chutkan overruled him with a single word: denied. By the third hour, Lauro had stopped objecting entirely. The most damaging moment came when prosecutors played an audio recording. The recording, reportedly obtained through a cooperating witness, captured a conversation between 2 members of Trump's legal team discussing a filing they were preparing. On the tape, one attorney says to another, "We both know this argument is garbage, but it'll buy us another 3 months, and that's what the client wants." Judge Chutkan stopped the playback and sat in silence for nearly a full minute. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. After the prosecution concluded its presentation, Judge Chutkan announced she would issue her ruling from the bench immediately rather than taking the matter under advisement. Legal observers in the courtroom say this was itself extraordinary, as judges typically reserve time to draft written orders for decisions of this magnitude. But Chutkan made clear she had seen enough. The bombshell moment came exactly 7 minutes into her bench ruling, when Chutkan looked directly at the defense table and delivered what legal analysts are already calling the most devastating judicial rebuke of attorneys in modern federal court history. "Counsel," Judge Chutkan began, her voice controlled but carrying unmistakable force. "This court has presided over cases involving murderers, terrorists, and organized crime figures. In all of those cases, defense attorneys, however aggressively they advocated for their clients, maintained the basic ethical obligations that make our adversarial system function. What this court has witnessed from this defense team is something altogether different." She paused, and the courtroom held its breath. "You have filed motions containing statements you knew to be false. You have concealed evidence this court specifically ordered produced. You have, by the evidence presented today, participated in communications that can only be characterized as attempts to obstruct this proceeding. This is not advocacy. This is not zealous representation. This is a betrayal of every oath you swore when you were admitted to the bar." The word betrayal sent shockwaves through the gallery. Reporters noted that Trump's attorneys sat frozen, their faces drained of color. Chutkan continued without pausing. "Effective immediately, John Lauro, Todd Blanche, and Emil Bove are stripped of their privileges to practice before this court. They are ordered to surrender their bar credentials to the clerk within the hour. They are prohibited from any further contact with witnesses in this matter, and they are referred to the disciplinary authorities of every jurisdiction in which they hold a license for investigation of potential disbarment." That's when it became clear this wasn't just a courtroom sanction. This was a wholesale destruction of legal careers. The ruling sent shockwaves through the legal community. When a federal judge not only strips practice privileges but actively refers attorneys for disbarment and prohibits witness contact, the implications extend far beyond this single case. The claims that this is politically motivated persecution collapse when the judge has documented evidence of attorneys admitting on tape that they filed frivolous motions solely for delay. This isn't the first time attorneys have faced severe sanctions for misconduct in high-profile cases. Think back to the aftermath of the 2020 election, when multiple attorneys faced disciplinary proceedings for filing lawsuits they knew lacked evidentiary support. Sidney Powell eventually pleaded guilty to criminal charges. Rudy Giuliani was disbarred in New York and faces disbarment proceedings in other jurisdictions. The pattern of attorneys facing consequences for abandoning their ethical obligations in service of Trump is now well established. Then there was the Watergate era, when several of Nixon's attorneys ultimately faced criminal charges and disbarment for their roles in the cover-up. John Dean, John Mitchell, and others discovered that representing a president doesn't exempt attorneys from the rules that govern their profession. The key difference now is that the misconduct has been documented in real time, on tape, in the attorney's own words. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the sanctions Judge Chutkan had already imposed earlier in this case. In October 2024, she fined the defense team $50,000 for filing a motion that bordered on frivolous. In November, she issued a formal warning after discovering that discovery responses were incomplete. In December, she threatened to hold counsel in contempt if deadline violations continued. Now, however, threats have given way to action. The pattern is unmistakable. When warnings and fines fail to modify attorney conduct, judges eventually reach for more severe remedies. So what specifically triggered this nuclear option? According to legal ethics experts who have reviewed the publicly available portions of Judge Chutkan's order, the combination of documented false statements, concealed evidence, and the recorded admission of filing frivolous motions left the court with no alternative. The order identifies 17 specific instances where defense filings contained statements contradicted by evidence the attorneys possessed. It documents 8 occasions where discovery responses omitted materials that were later produced only after prosecutors independently obtained them. It quotes extensively from the recorded conversation in which attorneys acknowledged their arguments were garbage, filed only for delay. Here's the kicker. The order reveals that one of the concealed documents was a memorandum from Trump himself, dated 2 weeks after January 6th, that prosecutors say demonstrates consciousness of guilt. The defense team had this document for 11 months and never disclosed it despite multiple court orders requiring production of all relevant materials. Judge Chutkan called this concealment the most serious discovery violation this court has encountered in 30 years on the bench. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone who cares about the legal system. This isn't just about one case or one set of attorneys. If lawyers can file motions they know are frivolous, conceal evidence under court order, and coordinate witness intimidation without facing career-ending consequences, the entire adversarial system breaks down. Once attorneys understand that ethical rules are merely aspirational when the client is powerful enough, the rule of law itself becomes meaningless. Every defendant, not just wealthy and connected ones, suffers when courts can no longer trust that attorneys are operating in good faith. This puts Trump himself in an extraordinarily difficult position. On one side, he has lost his entire defense team in the middle of the most serious criminal prosecution he faces. Finding replacement counsel willing to take the case will be extremely difficult given what just happened to the previous team. Experienced criminal defense attorneys are now on notice that representing Trump may result in career destruction. On the other side, the loss of his attorneys triggers automatic delays that, in previous circumstances, might have benefited him. But Judge Chutkan has already announced that no delays will be granted based on the defense team's own misconduct. She stated from the bench that a defendant cannot benefit from obstruction carried out in his name. And here's the tricky part. There's no credible defense for what the attorneys did. Either the recorded conversation is genuine, in which case they admitted on tape to filing frivolous motions, or it's fabricated, which would require believing that federal prosecutors manufactured audio evidence and presented it in open court. The documented concealment of the Trump memorandum is similarly indefensible. The document exists. It was in the defense team's possession. They didn't produce it. There's no innocent explanation. Legal and political analysts are calling this a watershed moment for legal ethics enforcement. Stephen Gillers, New York University law professor and one of the nation's foremost experts on legal ethics, told the New York Times that Judge Chutkan's order should be required reading in every law school in America. He explained that the ruling demonstrates that courts retain the power and the will to enforce ethical standards even against attorneys representing the most powerful individuals. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Alan Dershowitz, Harvard law professor emeritus and frequent defender of Trump, acknowledged on Newsmax that the recorded conversation creates an extraordinarily difficult situation for any attorney trying to defend what happened. He emphasized that while he believes Trump is entitled to vigorous representation, attorneys cannot file motions they themselves characterize as garbage, and if they do, they must expect consequences. A former federal judge named Nancy Gertner, who served on the District of Massachusetts for 17 years before joining the Harvard law faculty, issued a statement calling the ruling a necessary corrective at a moment when too many attorneys have concluded that ethical rules don't apply when the stakes are high enough. She noted that Judge Chutkan has reminded the legal profession that our obligations to the court are not negotiable, regardless of who our client might be. So let's break down what this could mean going forward. First, the immediate impact on Trump's case is severe. He must now find new counsel willing to take over in the middle of complex federal proceedings. Any new attorneys will need months to get up to speed on a case involving thousands of documents and dozens of witnesses. Yet Judge Chutkan has indicated she will not grant significant delays. Trump faces the genuine prospect of going to trial with attorneys who are still learning the factual record. Second, this creates cascading problems for his other legal matters. The attorneys who were stripped of privileges also represented Trump in related matters. Their removal from this case calls into question their ability to continue representing him elsewhere. The disbarment referrals will take months to resolve, and during that period, their ability to practice is compromised. Finally, the signal this sends to the broader legal community is unmistakable. Attorneys considering whether to represent Trump in future matters now know that aggressive tactics can result in career destruction. The pool of qualified counsel willing to take on this representation has shrunk dramatically. This may ultimately prove more damaging than any single ruling on the merits. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate practical consequences, this ruling is really about the integrity of the legal profession itself. Attorneys occupy a unique position in our system. They are officers of the court, bound by ethical obligations that transcend their duties to any individual client. When attorneys abandon those obligations, when they file motions they know are meritless, when they conceal evidence, when they participate in witness intimidation, they don't just harm their client's opponent, they harm the system that allows all of us to seek justice. Judge Chutkan's ruling is a declaration that these obligations still mean something. This ruling is causing sheer panic within Trump's inner circle. Reports indicate that emergency calls went out within minutes of the order seeking attorneys willing to take over the case. Multiple prominent criminal defense attorneys have already publicly declined. One, a former federal prosecutor named Mark McDougal, who has represented numerous high-profile defendants, told reporters that no amount of money would persuade me to step into this situation given what just happened to the previous team. The difficulty of finding replacement counsel compounds with each passing hour. Meanwhile, Trump's supporters are absolutely furious, directing their rage at Judge Chutkan personally. Social media is flooded with attacks calling her a radical activist and a deep state operative. They're demanding her impeachment, her removal, her investigation. To the base, this is more evidence that the entire system is rigged. But that argument becomes harder to sustain when the evidence includes attorneys on tape admitting they filed garbage motions for delay. Things escalated further when Trump himself responded within hours of the ruling with a series of posts calling Judge Chutkan a disgrace to the legal system and his former attorneys victims of political persecution. He claimed the recorded evidence was manipulated and taken out of context, though he offered no specifics about what context would make admitting to frivolous filings acceptable. He announced he would seek to have Judge Chutkan removed from the case, a motion legal experts immediately noted has virtually no chance of success. Stay with me. What comes next will completely change how you view this situation. Here's what makes the response even more revealing. Trump's reaction essentially abandoned the attorneys who just sacrificed their careers representing him. Rather than expressing gratitude for their service or defending their conduct specifically, the response focused entirely on attacking the judge and claiming persecution. Legal observers noted that this pattern, demanding total loyalty from those who serve him while offering none in return when they face consequences, has repeated throughout Trump's legal troubles. Attorneys watching this dynamic unfold have one more reason to decline future representation. Former prosecutors immediately flagged the deeper problem. When a client's response to his attorneys facing disbarment is to attack the judge rather than defend the attorney's conduct, it suggests the attorneys were following client direction rather than exercising independent professional judgment. That implication raises additional questions about what Trump himself knew about the conduct that led to these sanctions. This goes far beyond a single case or a single set of attorneys. It's about whether the legal profession can maintain ethical standards when powerful clients pressure attorneys to cross lines. If attorneys learn that serving certain clients means abandoning professional obligations and that doing so carries no consequences, the legal system cannot function. Every defendant, every plaintiff, every party in every case depends on the assumption that opposing counsel is operating within ethical bounds. When that assumption fails, justice itself becomes impossible. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has stripped 3 attorneys of their right to practice before her court, ordered them to surrender their credentials, referred them for disbarment, and prohibited any further witness contact. This action followed documented evidence of false filings, concealed documents, and recorded conversations in which attorneys admitted to filing frivolous motions. U.S. Marshals escorted the defense team from the courthouse. This is no longer about aggressive advocacy or zealous representation. It's about whether attorneys can abandon their ethical obligations when the client is powerful enough. When a federal judge takes action this severe based on evidence this damning, we've witnessed something that will reshape how attorneys approach high-stakes representation for decades. If there are no further consequences, if the disbarment referrals go nowhere, it sets a precedent that ethical rules are merely suggestions when the client is sufficiently important. Future attorneys will calibrate their conduct accordingly. Keep a close eye on this story. Trump must find new counsel within days or face the prospect of proceeding without adequate representation. The disbarment proceedings will unfold over the coming months, and the legal profession as a whole is watching to see whether this ruling represents a genuine enforcement of standards or an isolated event without broader impact. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 3 attorneys just had their legal careers effectively destroyed after a federal judge documented a pattern of misconduct, including false filings, concealed evidence, and recorded admissions of filing frivolous motions. Trump must now find new counsel willing to take a case that just resulted in disbarment referrals for the previous team. The trial date has not been moved. This isn't just another news cycle that will fade away. This is a defining moment for the legal profession. What happens next will determine whether ethical standards apply equally to all attorneys or whether serving powerful clients provides exemption. The evidence is on the record. The ruling has been issued. The careers have been destroyed. Now we wait to see if this represents the beginning of accountability or an exception that proves the rule. The stakes have never been higher. The evidence has never been more damning. And the crisis for Trump's legal defense has never been more immediate.